Well, there are a number of eligibility requirements for Chapter 12 bankruptcy, one of which has to do with gross income that's coming from farming. A recent case from New York has many raising questions on the matter. Our good friend Roger McEowen with the Washburn School of Law joins us now to break this down for us. Roger, thank you so much. Happy Monday morning to you. So I thought we'd start with some of the basic regulations when it comes to Chapter 12 and farm income. What do farmers need to know here?
Well, good to be with you, Suzanne, and happy Monday to you. You have to clear a 50% hurdle with respect to your gross income. In other words, more than half of your gross income has to come from farming. And that really is the rub in terms of what is viewed as gross income from farming for purposes of that test.
So that's the interesting question. That's the point. When it comes to farm income, what counts here when we're talking about Chapter 12? I know that this case in New York involves training and breeding horses, correct?
Yeah, that's right. And that's usually where we get the questions because the general test is that it's gross income from farming if your income is tied to risk of production, risk of price change. Well, if you're doing something that is more like a service business, then you can have questions. So if you're raising, training horses, giving riding lessons, providing breeding services, you can expect an argument from the creditors and maybe the bankruptcy trustee that income is not going to count as gross income from farming activities because you're not subject to risk of production, risk of price change like farming operations would be if they're growing crops or raising livestock and then selling those crops and selling the livestock. But if you are raising horses to maturity to sell them, then there are cases that says that income counts as gross income from farming. So that's really, I think, what the people need to be aware of if they're engaged with horsing activities.
So, Roger, how did this case work? What were the courts ruling on this?
Well, they got bounced out of Chapter 12. They were repeat filers, so they had that going against them. It's not to say that you can't file more than once. For example, put a plan together, have it knocked down by the court, and come back again and try again. The courts usually are pretty pro-debtor in the Chapter 12 setting. But here they were repeat filers. They didn't have a regular source of income outside of the income from the horsing activities. And the court looked at this and said, well, you're not raising horses to maturity. You're not using them in a farming operation or in a ranching operation, such as actual workhorses. We think you're providing a service, and the bulk of your income comes from that, and therefore you couldn't clear the 50% test, and you're not eligible for Chapter 12.
Obviously an important lesson here. Roger, thank you, as always, for breaking it down for us. Roger McEowen with the Washburn School of Law. Thank you, Roger.